2023. And even though some time has passed, the urgency and relevance of access to information has not. And as we begin, I would just like to pose a question to all of us to get us thinking. What's the biggest barrier to accessing information in your context? So here we recognize that in our midst we have people from civil society, we have people from academia and very different backgrounds, and also different nationalities represented from all across Africa. So what's the biggest barrier of accessing information in your context? Is it lack of legal frameworks? Is it poor implementation? Is it limited public awareness? Just write that in the chat and we'll get to it during the plenary. So with that, I want to welcome you all once again. You can stretch your legs and prepare for an exciting morning as we celebrate progress, as we address the challenges that we are facing in our different contexts, and also just have a great time of learning. So to officially set the stage for us, I would like to invite Lloyd Kuvea, who is our Assistant Director here at the center. Lloyd, over to you. And even as he welcomes us, he will be taking us now, launching as he invites the commissioner to take us to the exciting part of this meeting. Welcome, Lloyd.
Good morning, afternoon, and evening from wherever you are. And thank you very much, Ivy, for inviting me to open this very important launch, which marks, the 10 years and 20 years of all the work that has been done. And really quite excited as the Center for Human Rights. First of all, let me recognize the presence of Commissioner Topsy Sono, the Special Rapporteur on Freedom of Expression and Access to Information. Thank you so much for your leadership. And thank you so much for always making yourself available and supporting the work that is the units on freedom of expression, information, and digital rights is doing at the Center for Human Rights, University of Pretoria. We really thank you and we appreciate you. We know that you have a very busy schedule, and it takes a lot just for you to be here with us and support what we are doing. We also want to recognize Advocate Pansy Tlakula, who really pioneered the work on access to information when she was the Special Rapporteur on Freedom of Expression and Access to Information. We thank you, and as we also celebrate your legacy on access to information. There are also many other colleagues who contributed to the great work that was done, which we are now celebrating. I would also want to thank all the academics, researchers, and activists who are present in this webinar, and those who contributed, to the newsletter, the very rich articles that Ivy has alluded to. We really appreciate the thought leadership and the academic input and all the analysis that was done on progress that has been made over the past 20 years on access to information on our beautiful continent. Let me also take this opportunity to thank Tlengiwe for her leadership of this unit and the support that she has always rendered to the Special Rapporteur on Freedom of Expression and Access to Information, and the work that she continues to do across the continent, on access to information. I also want to thank her team, Ivy, Enoch, who have really worked hard to ensure that we have a successful webinar, and also the other colleagues in the unit who are maybe not available today to join this meeting, including Tendai, Mbanje, and also I would like to really thank the broader community within the Center for Human Rights. We have also supported this unit, particularly the leadership of the center. As I welcome everybody, just to say that this unit is one of 10 other units that we have at the center that continues to do human rights work, promoting human rights and protecting human rights across the continent. And also, I just want to acknowledge the fact that the academic programs at the center, one of which is the Human Rights and Democratization in Africa, continues also to produce more researchers, more advocates who are going to push and continue to do this work that we are celebrating today, and many other human rights issues that are affecting this continent. Just to say, Ivy, for me, maybe one of the stumbling blocks or one of the challenges that we have faced with access to information. For me, I think the biggest challenge is implementation, because I think, as you say, we have 27 countries that have, adopted laws on access to information or freedom of information. But I think the lack of political will sometimes gets into the way. And implementation is really, for me, been a big challenge, the lack of implementation. So perhaps we need to do more advocacy to ensure that the model laws that are existing on the continent, are implemented to start with, then provide inspiration. And as we continue also to advocate for adoption of access to information laws across the continent for the remaining 50% of the African countries that we have. But really, just to say, it's a pleasure really to open this launch, and I'll hand over to Commissioner Topsy Sono to really give us the keynote address, and help us with the launch of this very important newsletter. For me, I think in terms of progress, some significant progress has been made. I mean, at least it's a good start that we have 50% of our countries on the continent adopting, access to information law. Thank you so much. Thank you so much then to Commissioner Pansy and a team who developed the model law. And I think I once witnessed Advocate Pansy Slakula and their team crisscrossing the continent, getting countries to really adopt access to information laws. Thank you so much for your hard work, which we are also celebrating. And I think, of course, the challenges will always be there, because we have a big continent. And I think we are going to be looking at all those issues regarding the challenges. We have people here who are going to speak to some of those issues. And so I hope that we are going to have a very good and comprehensive and exciting 2 hours as we analyze the progress that has been made, look at the challenges, and then also look into the future. What should we be prioritizing now? Should we be prioritizing implementation? Should we be prioritizing adoption of laws by all countries on the continent? And also, should we be looking at issues around, the impact of artificial intelligence, the impact of technology, on access to information? So there's so much that we're going to discuss today. But I do not want to take too much time in welcoming everybody, because I know that there are so many presentations to be made. So without further ado, I want to then say a warm welcome and wish you very fruitful deliberations as we launch this very important newsletter on access to information in Africa. Commissioner Topsy Sono, thank you so much. I would now want to invite you to deliver your keynote address. Over to you. The floor is yours.
Thank you, Lloyd. So, good morning, afternoon, and thank you for being part of this event. Distinguished colleagues and participants, I warmly welcome you all to this important gathering, and I'd like to thank the Center for Human Rights of the University of Pretoria for convening us today. The Center continues to be an indispensable partner in advancing freedom of expression and access to information across the African continent. And I commend their team for not only preparing this timely and insightful publication, but also for convening this space and sustaining a vibrant ecosystem of scholarship, policy, and advocacy around access to information in Africa. It is indeed my privilege to deliver this keynote address on the occasion of the official launch of the Access to Information newsletter, a publication that captures both reflection and vision, grounded in the commemoration of a decade of model law on access to information in Africa. Allow me, first of all, to acknowledge a figure without whom we might not be celebrating this milestone today, namely Advocate Pansi Takula, my predecessor, and a true pioneer in the field. As many of you may know, Advocate Takula served as Special Rapporteur on freedom of expression and access to information in Africa from 2005 to 2017. Her contributions during that period laid the very foundation upon which much of today's progress has been built. The model law on access to information in Africa was conceptualized, developed, and adopted in 2013, making it the first time that a regional human rights system provided such a comprehensive blueprint for national access to information legislation. She spearheaded the development and adoption of the guidelines on access to information and elections in Africa, thereby reinforcing the critical link between transparency and credible democratic processes. She also initiated and laid the groundwork for the 2019 revision of the Declaration of Principles on Freedom of Expression and Access to Information in Africa, ensuring that digital rights, access to information, and data protection were brought into the modern human rights framework of the African Commission on Human and People's Rights. Today, as chairperson of the Information Regulator of South Africa, Advocate Takula continues to exemplify principled leadership and institutional strength in championing transparency and data protection. It is an honor to share this platform with her, and I take this opportunity to thank her publicly for the path that she has shared and with us and that she has charted all throughout. Advocate Takula, your legacy continues to guide and inspire us. We are indeed honored to have you with us today. So we go for the model law on access to information, which was adopted, as I stated, by the African Commission in 2013 and was conceived to advance access to information across Africa. It reflects international best practices, but is uniquely grounded in African context. Over the past decade, it has served as a valuable advocacy tool and a technical guide for national legislative reform. A big part of the progress we have seen is thanks to the model law and the efforts of civil society, researchers and information commissioners, and committed policymakers. We have seen a remarkable expansion in access to information laws. In 2013, we had only 5 African countries having such laws. Today, we have 27 such countries. This is a progress that we must indeed celebrate. However, there are significant gaps that still persist. Nearly half of the African Union members states still lack access to information laws. Amongst those that do, several framers fall short of the regional and international standards. Even where strong laws exist, they are all often undermined by weak implementation, insufficient resources, and lack of political will. We know that passing of laws is only the first step. Implementing them effectively is where the real test lies. Some of the key challenges we continue to face include institutional and political resistance to transparency, inadequate funding and limited capacity within the oversight bodies, low public awareness of the right to access information, and emerging digital obstacles, including algorithmic bias, disinformation, and unequal access to digital platforms. The newsletter that we launched today is more than a commemorative publication. It is a timely platform for critical reflection and dialogue. It brings together contributions from researchers and experts across the continent, from the 2023 seminar held to mark the 10th anniversary of the model law. The various articles explore, namely the domestic application of the African Union standards on access to information, the implementation challenge faced by oversight bodies, the role of technology, from digital platforms to algorithmic transparency, the growing threat of information disorder, misinformation, disinformation, main information. Therefore, distorting public understanding and trust. This publication underscores that the right of access to information is not theoretical, it is practical, lived, and urgent. The newsletter contributions rightly explore the impact of the digital age. Our context today is shaped by powerful contradictions. On the one hand, we have the digital age that offers unprecedented possibilities for access, participation, and civic engagement. But on the other hand, it introduces new threats such as internet shutdowns to algorithmic opacity, from digital exclusion to weaponization of false information. Some states continue to criminalize legitimate expectation, restrict civic space, or shut down the internet in moments of crisis. Such actions are fundamentally incompatible with the rights enshrined in Article 9 of the Charter, the model law, and the guidelines, as well as the 2019 declaration. As I noted in the preface to this newsletter, we must urge all African Union member states to firstly adopt or revise the access to information laws in line with the model law, the guidelines, and the 2019 declaration. We must ensure universal, affordable, and meaningful access to the internet, which is now an integral part of access to information, freedom of expression, and the exercise of other fundamental rights. We must also empower the public, particularly in rural and marginalized communities, with the tools and digital literacy needed to seek, receive, and share information effectively. In 2024, we mark the 20 years since the establishment of a special mechanism of a special rapporteur on freedom of expression and access to information in Africa, which was established by the African Commission in 2004. The 20-year mark was a moment to reflect on the evolution of the mandate and the state of access to information and freedom of expression across the African continent. Over the past 2 decades, the Special Rapporteur mechanism has helped bring visibility and momentum to two of the most essential rights in democratic societies, the right of freedom of expression and that of access to information. These rights are cornerstones of civic participation, transparency, and accountability, and they remain under constant pressure, especially in today's digital and geopolitical climate. As the current mandate holder, I am deeply honored to preside over this pivotal moment. I reaffirm my commitment to working with all stakeholders, governments, information commissioners, media, civil society, academia, and the public, and to advance access to information and freedom of expression, online and offline. Throughout these partnerships, we can ensure that information rights are not just aspirational, but actualized, building a continent grounded in good governance, transparency, and participatory democracy. We have gaps, as Lloyd has stated, but I think we need to deepen the implementation and monitoring of states, and states must move forward from commitment to action. This means resourcing information commissions, developing robust public record systems, and ensuring timely and proactive disclosure across all sectors. We must also strengthen legal and digital safeguards. The intersection between technology, misinformation, and access rights must be addressed with clarity and regulation. Information must remain accurate, inclusive, and accessible in both analog and digital environments. We must also reaffirm regional and global solidarity. The African Commission, through this mandate, We'll continue to support state, civil society, and national institutions, but collaboration across borders, across institutions, and across generations is key to keeping the momentum alive. As I conclude, let us be reminded that access to information is not merely about compliance, it is about empowerment. It enables the public to participate meaningfully, to demand accountability, and to shape the decisions that affect their lives. Let us continue to build on the foundations laid by visionaries like Advocate Takula. Let us ensure that the model law and the 2019 declaration are not just read, but implemented, enforced, and lived. To the Center for Human Rights, I commend you once again for your diligent preparation of this newsletter and your continued advocacy for the full realization of this right. Your work is essential. And to all of you here present, let us move forward together with urgency and resolve. The right to know is the right to live with dignity. Let us protect it, promote it, and practice it. Thank you.
Thank you. Thank you very much, Commissioner. That was powerful. You have reminded us that there is progress to celebrate, but that also the 2 decades that we've had of commitment still demand daily action. Thank you for that. Also, thank you, Lloyd, for having welcomed us and for setting the stage. So we would also now like to hear from Advocate Pansy Tlakula, who has been mentioned by the 2 previous speakers, but I can't see her on the call, although I see other members of the information regulator present. So Kelani, please guide us on whether there is someone who is, yes, Advocate Pansy is here. Thank you. So for those who are meeting her for the first time, this is, she was the former Special Rapporteur on Freedom of Expression and Access to Information, and currently the chairperson of the South African Information Regulator. Advocate Pansy, it's a pleasure to have you and to get to hear insights and reflections on the oversight institutions and the implementation of access to information laws. Welcome.
Let's see. Okay, thank you very much, Program Director Ivy. It's an absolute pleasure to be here today. Let me start by recognizing my sister, Honorable Commissioner Topsy, and thank her for the very kind words that she said about me, and also the work that, and thank her for the work that she is doing in taking the struggle for transparency forward through her mandate. I also would like to thank the Center, not only for putting this newsletter together and for this launch, but for the pivotal role that the Center played during the drafting and the adoption of the access to information, during the drafting and adoption of the model law on access to information. And as Commissioner Topsy has said, the model law was drafted and adopted during my 12-year tenure as the Special Rapporteur on Freedom of Expression and Access to Information. 12 years, it's a very long time. I felt that I was the longest serving Special Rapporteur at that time because my European, my UN, and my inter-American colleagues came and went, and I was still standing, which was very fascinating. Had it not been the funding that we got from the UN Democracy Fund, the Open Society Foundation would not have been able to draft the model law. And it's also important for me to acknowledge all the African experts who gave their time freely without remuneration to draft the model law on access to information and to accompany me during that grueling period where we went from country to country in the 5 regions of our continent, for consultations on the model law before it was adopted. I think it is important to mention this because some of those experts are here, like Mukelani Dimba, my colleague, people like Maxwell Kadiri, who was really spearheading also the consultation processes with Lola Olalade, who was still at the center at that time, and many others that I have not mentioned. I would like also for them to be recognized for the model law, which without any shadow of doubt was one of the most impactful projects that was undertaken by the African Commission on Human and People's Rights. Of course, the model law on access to information has a chapter on oversight bodies. And I want to reflect, as I have been requested, on the oversight institutions in the implementation of ATI laws. But before I do that, we have to acknowledge that the model law contributed in increasing the number of ATI oversight bodies in Africa, as the Honorable Commissioner has already stated. But before I reflect on the oversight institutions and their role in implementing ATI, I think it is important to put on the table the successes that the model law has contributed to in this area. So, as African ATI bodies, we have managed to form the African Network of Information Commissioners, which is an association of access to information bodies on the African continent. And we established ENIC, as we call it, to share experiences and for peer learning. And as ANIC, we have managed to influence the global ATI agenda because in 2024, during the annual general meeting of ANIC, which was held here in Johannesburg, we adopted an outcome statement, which we call the Johannesburg Outcome Statement. And the heading or topic of that, the theme, not topic, the theme of that statement is the role of access to information oversight bodies in advancing information integrity in Africa. And this statement recognizes that information integrity is necessary for the free flow of accurate, reliable, and credible information, which, as the Honorable Commissioner has already stated, is threatened by disinformation and misinformation. And as ANIC, we have spearheaded the establishment of the working group on information integrity at the International Conference of Information Commissioners, which is the global association of ATI oversight bodies. And we have also ensured that we participate in the leadership structure of the ICIC because 2 African countries, being ourselves, in fact, 3 ourselves, Kenya and Sierra Leone, we serve on the executive committee of the ICIC. And in addition to that, we pushed that the ICIC must be held in 2026 in Africa, and it will be hosted by Sierra Leone. So in 2024, when we attended the General Assembly of the ICIC in Albania, we pushed, as I've said, for the establishment of the Working Group on Information Integrity. And we succeeded because the working group is now established, has now been established, and South Africa and Kosovo are the co-chairs of this working group. Had it not been of the model law, which increased the number of countries that have adopted the ATI laws and established oversight mechanisms, would not have been able to influence the global agenda on ATI as we have done as a collective in Africa. I thought it was important to mention this achievement before we come to challenges in implementing ATI laws. Now, the first problem that we have as ATI oversight bodies is that most of us overseeing dated legislative frameworks. Our ATI laws are dated and have to be brought up to speed because they do not take into consideration technological advancements that have occurred globally. And these frameworks, I think, are not fit for purpose because most of them, and not only in Africa and globally, most of them deal with access to public information or information held by public bodies. Yet private bodies, in particular digital platforms, hold enormous amounts of data and information that can be used or accessed for various purposes, including for development, including for business purposes, research, and so on. And yet ATI laws do not apply to private bodies. And the platforms in particular, the digital platforms, as Honorable Commissioner has said, also are used to spread disinformation and misinformation. And because ATI laws do not apply to them, they cannot be held accountable. We cannot access information from them on how they counter disinformation and misinformation. We cannot access information from them on the budgets that they spend on this and the research that they do. So that is why I'm saying that most of our ATI laws are outdated. The independence of oversight bodies remains a challenge because without real independence, they cannot perform their functions without fear, favor, or prejudice. So we have to consistently push for the independence of these institutions. And some of the laws have weak or ineffective enforcement powers. And I will give an example of South Africa. In South Africa, the information regulator, which is the ATI oversight bodies, has reasonably decent enforcement powers because once we have investigated a complaint and we have issued an enforcement notice to the effect that information should be disclosed, then our enforcement notice is binding. It cannot be ignored unless it is challenged in a court of law within a period stated in the Act, which is 180 days. If our enforcement notice is not challenged within 180 days, the next step is that we should then institute criminal proceedings against the information officer or head of a private body that has ignored our powers. And we have done so now already in 2 instances. But the problem with that is that we institute criminal proceedings, but the information remains undisclosed. So this is the weakness in that system because yes, you can institute criminal proceedings, well and good, but I think we are saying, and this is what we're advocating for and approaching the lawmakers to say, at the same time, after the 180 days, let's institute criminal proceedings, but let us also release the information. So this is one of those weaknesses that we have sort of picked up, and we are going to be approaching the lawmakers to see if we can get the law to be amended. Of course, financial and human resources are a challenge for all of us, as Honorable Commissioner has indicated. And as oversight bodies, we must find ways of becoming self-sustainable because in the climate of the fiscal constraints that we are all operating under. If we are not self-sustainable, it's going to be difficult for us to continue to do our work and to be effective. For instance, let's look at whether the laws can be amended so that one of the powers that we have is to levy fines, administrative fines, where there has been non-compliance, and that those fines or a percentage of the fines can come to the oversight body instead of all of it going to the fiscus. And also some of us register information officers and see if we cannot levy a registration fee which we can keep so that we can then increase our budgets. The last one in the 5 minutes, and I'm sure I've exceeded the 5 minutes, is fragmentation. Because in most of our countries, ATI and privacy or data protection are dealt with by two separate bodies. And most of the time, those bodies are poorly funded. Yet, access to information and data protection or privacy in this age of in the digital era that we are in, ATI and data protection complement and balance each other. And I think we also have to increase the movement and the lobby to ensure that ATI and data protection are dealt with by one oversight body. In South Africa, it is the case. I'm also pleased to report that Botswana has just established a commission which is also responsible for both data protection and access to information. And I know that even Sierra Leone is pushing in that direction. So these are my reflections. And once again, thank you very much for inviting me. And I wish you all the best in the launch of this exceptional newsletter and wish the center strength as it continues to do the important work that it does on the continent. Thank you very much.
Thank you so much, Advocate Lakula. You know, every time you speak, it's a masterclass. Your insights here remind us that there is knowledge that does not live in books or in policy papers, but instead it lives in experience, in the bold steps that are taken to shape institutions and also in that steady voice that has championed for freedom of expression and access to information all across the continent for years. So we are deeply grateful to have your continued leadership. So thank you once again. To everyone else now, just a reminder, I had posed a question at the beginning. I had asked, what's the biggest barrier to accessing information in your context? And some have been alluded to by Advocate Pansit Lakula: lack of legal frameworks, poor implementation of enforcement, and so on. So please type your answer in the chat. We'll get to them during the plenary. For now, to share a little more about the newsletter and to guide us to the launch of it, we are going to have Hlengiwe Dube, who is the manager at the center for the unit that is freedom of expression, access to information, and digital rights. The screen is yours, Hlengiwe.
The screen is mine now. Thank you so much, Ivy, and thank you so much, Advocate Pansit Lakula, for taking us through the role of information commissions on the continent. We know that they play a very important role in the implementation of access to information legislation, and it's not been an easy road. And but there has been remarkable progress as we have highlighted. Thank you so much for that. So without wasting my much time, I'm going to move on to the newsletter itself. So this is a publication that we put together in 2023. We did commemorate the 10 years of the model law and access to information through a number of initiatives. There were some podcasts that were recorded. They featured some of the experts on access to information. They featured some of the information commissions. We had also a symposium, and the articles that are in the newsletter were presented in that symposium. And some of the activities, there were some other activities as well that we undertook. So we then put together the articles into the newsletter that has been shared with you in the chat. So these are contributions. Some of the contributors were academics, some of them are activists, and they provide like an overview of the state of access to information on the continent, reflecting on some of the challenges that have been alluded to, the lack of resourcing, for instance, of information commissions, the issue of misinformation and disinformation, and some of the challenges that we experience as a result of the digital age as well. We also have some articles that are focusing on the role of artificial intelligence and the impact on information access, and also, internet shutdowns as well. Some of them are general, but we have some that are looking specifically at the issue of elections across the continent. Then we have country spotlights. We have a number of presentation of articles that are looking at countries such as Namibia, examining, for instance, examining transparency under their new access to information legislation. We have the election focus on Zimbabwe, looking at information disclosure practices and compliance with the continental standards. We have, a spotlight into the Nigerian situation, looking at the implementation realities of its access to information law. And then in Ghana, we looked at the challenges faced by journalists. And then in Uganda and Ethiopia, there was, a reflection on the restrictive laws, digital repression, and also some of the election-related challenges. And we have one of the articles looking at rural communities, these are vulnerable and marginalized communities facing unique challenges on access to information. So we have one of the articles specifically looking at the rural communities, and also spotlighting the role of community media and how it ties into the conversation around access to information and some of the challenges that community media face, particularly in the digital age. And we have an article focusing on Sudan, the internet shutdown, looking at it from the perspective of it being a wartime tool. We also have other cross-cutting themes that look at the role of misinformation and disinformation in shaping the information ecosystem. And then also some of the legal, economic, and social barriers that are experienced that undermine effective and implementation of access to information legislation as well. So these are some of the discussions that we have, or articles that we have in the newsletter. Which I believe, if you look at just the different themes that are featured there, you can agree with me that it is indeed a timely publication, and also just reiterating that access to information is a foundational right when you look at issues of democracy, issues of transparency, issues of accountability, and also just if you look at sustainable development as well. So that's the breakdown of the newsletter. I'm going to just call upon Commissioner Topsy to just officially present and launch the newsletter. Thank you so much, Commissioner. Over to you.
Thank you, Jube. So today we have a newsletter thanks to the Center for Human Rights. So it is not just a newsletter, it is a renewal of our collective commitment to transparency, accountability, and democratic participation. Let us build on 2 decades of special rapporteur mandate with courage, clarity, and conviction. Access to information is not an abstract ideal. It is a living right shaped by courts, exercised by journalists, demanded by civil society, and realized for institutions like those represented here today. Let us ensure that across our African continent, every person knows that they have a right to know. With that, I declare the Access to Information newsletter officially launched. Thank you.
Thank you very much, Commissioner. I'm just going to ask my colleague Simpiwe to just share the screen and show us the newsletter so that our colleagues can just get a glimpse of the newsletter itself. Simpiwe, are you able to share the screen? Simpiwe? And also in the chat, if you check in the chat, we have also shared the newsletter. You can download it. I am re-sharing it again in the chat section, the newsletter. I'm sure you have received it. Simpiwe? All right, thank you so much. So colleagues, you have the newsletter in the chat. Please enjoy the reading, and this is not a once-off issue. The 10 years of the model law. We continuously going to be advocating for access to information, and we encourage you from the stakeholder community that you represent to also support us in advocating for the implementation of these normative frameworks like the model law, the guidelines on access to information, the declaration on access to information, and also support the special rapporteur on freedom of expression and access to information as well. And also you heard that there is ANIC, a network of information commissions. Please also do check out the work that is being done by the information commissions and support them in the work that they do in the different countries where these information commissions exist. So there is the model law on the newsletter on the screen there. So I'm sure that you can also just browse through individually and read in your own time. But otherwise, that's what we have. We're also going to share a link from our website where you can also access it and share with others as well. Over to you, Ivy. Thank you so much, Commissioner.
Thank you. And with that, the newsletter is launched. So these are the moments you miss physical engagements because we would have had some fireworks and, you would be tossing glasses. So, but anyway, we take what we have. Thank you so much, Commissioner Topsy. We are grateful that you are here. We're grateful for your support thus far. Your support gives weight and meaning to moments like this. We know that you are very busy, and even today you had court to attend and things like that. But your being here is making a difference. You are opening doors for deeper engagement, for stronger institutions, and more informed citizens across the continent. We are honored to have you and to have had you also mark this milestone with us. So thank you once again. So now to this newsletter that Enoch is teasing us with. What's in it? What's our lineup looking like today? It's nothing short of spectacular. We'd like to just hear from the researchers and the advocates who are shaping access to information on the ground. And so the presentations are going to just be a few, 3 of them, that we'll be looking at the constitutional frameworks to artificial intelligence and algorithmic transparency. So buckle up, it's going to be a fun ride. And before we hear from our first author, I'd like us to just take a moment and acknowledge all the brilliant contributors that are behind this new letter. We won't have time to hear from each one of them today, but just to acknowledge that their presence. If they could raise their hands and we just see them, to tell them we see you and we are grateful for what you have done. I'm looking to see if the hands are up. Our wonderful contributors and authors, if you could identify yourselves. Anyway, what we're saying is that we are thankful, and we'll just move then to the next. Thank you, Nicholas. Yeah, and the team. So our first author is Dunia Prince. Dunia is a consultant, an academic, and an author. He currently serves as an associate professor in the School of Law at the University of Namibia and as an adjunct associate professor at Walter Sisulu University, South Africa. Previously, he spent a 2-year stint at the Alliance School of Law in India. Zongwe specializes in law and economics, decoloniality, human rights, and higher education, and focuses on South Africa, India, and the Global South. He has published 4 books and over 60 articles, papers, and chapters. He's a World Bank consultant since 2013, having worked independently as well and in teams on projects for clients, including the Namibian Labour Ministry, UNESCO, and the Law Society of Namibia. He has presented lectures at more than 90 conferences worldwide. He received several merit scholarships and awards, including notably a highly productive researcher award from Walter Sisulu University in 2022. Yeah, in 2022. And the LSN Prize for Best LLB Student in 2007, and the UNAM Vice Chancellor's Medal twice. So he is a UNAM LLB graduate, cum laude, fluent in English and French, and he earned his master's degree and doctorate in law at Cornell University, USA, and also has a certificate in higher education from Rhodes University. Dunia, it's a pleasure and an honor to have you with us today. Take it away, just a few minutes. Yeah.
Yes, good morning. Can you hear me?
We can, and we can see you as
Yes,
well.
Thank you very much for the introduction and for inviting me at this milestone. I feel very honored and privileged. I'll be sharing my screen. I know I only have 5 minutes. It won't be long. It's just actually sharing with you just the structure of the article. I will not be going into it in detail because I'm aware that I have very little time. So can you see my screen?
Yes, we can.
Okay, so as I speak, I will be, I'll leave it there so that people can see the structure itself. I will not go through all of it because I would simply invite you to look at the newsletter and to click at the link. It's available online. Okay, I would like to start, and it relates to the question that we've been asked at the beginning by Ivy. What's the biggest barrier to access to information in your context? Before I answer this question, let me simply say that it was actually last week that I had a meeting with one of the regulators in Namibia. And I remember I was pointing that the confidentiality clause in the enabling law of that regulator was not actually good for business. It was harming that relevant market. And those were senior officers rather from the regulator, and they looked very puzzled, surprised. Some probably even had suspicion. They were saying, but so you're actually saying that we should remove that clause from the enabling law? And I explained to them that actually, it is not the law that, the clause that I want to be changed. Is the fact that I recognize that some information are privileged, but it's the fact that that clause did not have any independent mechanism for distinguishing between protected information and information that could be shared with the market so the market could work more efficiently. So it will answer the question that Ivy asked us, but I wanted to put, first of all, this framework before I actually deal with my presentation, the importance of the Namibia's Access to Information Act, which was passed in 2022, will be, clearly appreciated when you look at the recent history. In November 2019, Namibia's ugliest corruption scandal was revealed, and it was revealed through massive leak by journalists. So, and this is important because it shows that there was no mechanism first of all, for them to get that information. And what the Access to Information Act did is to provide that framework, which didn't exist before. But the courts were already going into that direction, and I would like to mention at least cases, the Gondwana case and the Aufiku case. In the Gondwana case, the High Court of Namibia said that the government cannot simply invoke the confidentiality of cabinet documents. They have to make a case for disclosing, for hiding for maintaining the confidentiality of cabinet documents. And in Aufiku, which was decided earlier in 2019, the Supreme Court of Namibia this time around told the Namibian intelligence services that you cannot block a journalist from publishing information on alleged corruption in the intelligence services simply by raising the national security, justification. Simply by raising national security. It needed to be justified. And that is an important thing to mention, because what the Namibia's Access to Information Act is to create a culture, not to create a culture, is to induce people to justify why they are classifying information and why they should not classify it. So if implemented, it's going to lead to a culture of justification. So the Silk Road scandal was the largest scandal in Namibia's history, in the sense that it involved domestic interest, foreign interest in Iceland. It happened in the fisheries sector, and it led to the arrest and the ongoing prosecution of the former justice minister and the former fisheries minister. It was a kickback scheme that was uncovered, as I said earlier, through information leaks. There was no legitimate disclosure mechanism or mechanism for journalists to access that information. And this is one of and these gaps fundamentally weakened constitutional checks and balances. So it's a constitutional milestone, the 2022 Act. I have to mention at this point that it has not entered into force yet. It has been promulgated, but the general understanding is that the government is using this time to set up the institutions created by the Act, and other, and also preparing the regulations that will govern the commissioner, for example, the commission. So one key innovation, and I particularly emphasize this in my my piece, is a presumption of disclosure. The presumption of disclosure is important because it presumes that the public entity or the private entity must disclose that information. And this is especially important, again, in light of what I was saying in the introduction, that it seems that currently there is a presumption of secrecy. Namibia is a constitutional democracy, but there's a lot of information that doesn't yet circulate within society and within the economy. Although the Act recognizes interests that will justify secrecy, such as legal privilege, national security, commercial sensitivity, and privacy, it has a section, it has in Section 64 a provision that allow people to override those justification if, for example, disclosure would reveal evidence of corrupt activities. And since we're talking about the model law, and this is very much about the model law, it's important to mention at least two ways in which the Act complies with or aligns with the 2013 model law. there are several ways in which, but I think two major ways is by what the provisions on the establishment of an independent and impartial commission, but also the structured request procedures. And this demonstrates Namibia's commitment to harmonizing domestic law with international standards, and it positions Namibia also as a case study, something that maybe other African countries can learn from. But there is a critical loophole, and the critical loophole here in the Act is the fact that, contrary to the Gondwana case, the Act actually exclude cabinet proceedings and cabinet documents from disclosure. I think it waters down the presumption, because it doesn't say that the presumption doesn't say that cabinet documents cannot be protected. It can be protected for those general reasons that I've mentioned: national security, commercial sensitivity, etc., etc. But this is a blanket removal of cabinet deliberations entirely from the scope of the Act. And this is the last major loophole that could enable officers to engage in the kind of corruption that has led to fish rot. Another I won't say loophole, well, it's a loophole, it's a legislative lapse, is the fact that it does not mention the constitutional provision on freedom of expression. And this is very important, because as I was thinking about the meeting I had last week, I realized that if I were to use the Access to Information Act to justify why the regulator should nuance its confidentiality clause by at least creating a mechanism to distinguish between protected and unprotected information, it's going to be difficult, because there are two acts of parliament, and there's no reason to believe that the that the Access to Information Act should supersede the act establishing that regulator. But if there was a reference to the constitutional provision on freedom of information, or freedom of speech, it would have made the case stronger. It would have allowed an interpretation that would have induced the regulator to comply with the terms of that act. I see Ivy is appearing on the screen, so I believe my time is up. I would end with the observation that I made earlier when I was, it will just take 1 minute, when I was talking about my meeting with the regulator. So to the question that Ivy asked, what is the biggest obstacle? From this very recent experience, I would say it's the office culture. I know the deputy director mentioned implementation. I will add a twist to it. It's the mindset, the culture, the office culture that needs to be changed, shifted from a culture of secrecy to a culture of disclosure, from a presumption of secrecy to a presumption of disclosure. So thank you very much for your time. I hope I did not exceed minutes by too much. So I apologize for that. And thank you again, once again, for inviting me at this milestone. Thank you so much.
Thank you also, Dunia. I also got carried away and forgot about the time for a minute there. I was engrossed. And is your final remarks are that moving from a culture of secrecy to a culture of disclosure. And if not for anything else, we have now understood the fish rot scandal, that all this access to information is more than just paperwork. It's about accountability. It's about the right to know. And thank you for that. Any comments or interventions on that, please just hold them or include them, write them on the chats. Once we've heard from Wendy and from Nomiezo, we will have a plenary session where we can engage with them a little more. So without much ado, our next author is Wendy Ashikomela, is a Kenyan national, an advocate of the High Court of Kenya, admitted to the bar in 2023. She is a holder of a Bachelor in Law degree from the University of Nairobi and a postgraduate diploma from the Kenya School of Law. She is currently a human rights master's student at the University of Pretoria. So Wendy is now practicing at a fintech company in Kenya and has specific interest in the field of law, and technology, intellectual property, human rights advocacy, and corporate commercial law. She is interested in the intersection of human rights and technology. So Wendy's presentation today will be on technology and access to information, the effect of such algorithms on access to information. Wendy, take it away in 5 minutes, please.
Thank you so much, Ivy. I will try to keep time. Good morning, good afternoon, good evening from wherever you are. Thank you for making the time today, and thank you for inviting me today to speak about my paper. The title is Technology and Access to Information, Effect of Such Algorithms on Access to Information. So arguably, we are currently living in the fourth industrial revolution, as it is coupled by the various technological advances. And perhaps something that you have had a lot during this period is AI. And when you hear AI and the internet, one thing that comes to my mind is algorithms, because that's basically like the backbone of the internet, because algorithms are like machine learning techniques that have been programmed and programmed to give certain output based on the information that they are given. And that information is basically fed to them by humans. So algorithms are created by human beings, they are trained and they are programmed by human beings. So how they work is they are given that information and then they'll give out a specific output, so that in the event that I, Wendy, have certain biases and I incorporate those biases when I am developing that such algorithm, then I get to, those biases might actually reflect in the output that is given by that algorithm. And that basically brings us to the challenge that we have with access to information, because with the internet having vast information, you may not know sometimes that you're actually being limited your right to information, because there is so much and you can only consume so much as well. So that is why sometimes, even when you're accessing the internet, you go to your Google, you search for a phone, and then you go into your social media platforms, you go into Instagram or Facebook, and you're getting constant ads about phones, and you're wondering, did they hear me or what is happening? But the idea behind how algorithms work is basically, once they've been trained and programmed and deployed to us to use them, then they study your behavior. So your behavior on the internet, so that whatever you're consuming is whatever they want to bring to you. And it might raise questions of data protection, because if I searched for something on Google, where am I seeing it on Instagram? But that is a debate that this paper did not dwell on at this particular moment, but it is a worthy debate to have. So it brings us to the major challenges that we have in the use and the age of the internet when we're accessing information. One thing about algorithms, because they study your behavior and now they'll give you content that is tailor-made to what you require, they create what we call echo chambers and filter bubbles. Echo chambers are basically where they only provide you content which is ranked, like based on what is highly ranked according to the algorithm. And like I said, it is trained by a human. So according to what the programmer thought is what is highly ranked. And then when you go to filter bubbles are now, they just limit your access to your access to information to things that you actually agree with alone. So that if you do not agree, let's say if you do not agree with feminist views, that will not come when you search for that. They will only give you what you believe in and what you actually agree with. And the challenge with that is that then it creates room for misinformation, and it can easily mislead people, because then you have this one myopic view about issues because you don't get to see diverse information. Another challenge that comes with the use of algorithms is the blocking and filtering of content. So blocking of content refers to a situation where you do not have access to certain sites. And this has been misused, especially by the states during states of war, or even when there is political unrest in a country. So they do that and block access to certain sites, perhaps where people are actually getting information regarding how the war is going or how the political or civil unrest is going. So that can be a challenge because then you will not be aware about what is actually happening. And filtering can be a good thing depending on the context, because when you talk about filtering, this is where they use technology, and in this case it's just AI, and they give it certain characteristics so that AI will look out for certain characteristics, and based on what it picks, then it will not show certain content. It can be good in terms of perhaps if it's a child using a phone, then they may not be able to access certain sites, but it can also be limiting because then it limits the ability of people to actually express themselves. Perhaps, let's say, if your culture maybe deals with celebrates things differently. Let's say you slaughter a goat and whatnot. If such content is posted, that AI will just pick the use of violence because it will see there is blood and then there's a knife and all that, and it will cut that content, and you will want to be able to receive that. And then the other danger that I forgot to mention when you talk about echo chambers and filter bubbles is the control and manipulation of algorithms. For example, in 2019, there were allegations against Google that it re-engineered their algorithm to only and restricted access to certain sites. And then now the algorithm was to favor big businesses alone, so that if you're searching for anything, it just brings big brands to you. And that is disadvantageous from a business point of view, because then you won't be able to, the small businesses will not be given a fair chance in perhaps marketing their product. In conclusion, based on these challenges that we have highlighted, I believe there are certain things that we can do to actually improve access where the internet is involved. For instance, we can collect feedback from diverse groups of people. This way we avoid the bias that AI has, so that if it's a system that is going to be used in Kenya, perhaps collecting feedback from Kenyan people would be important to know their perspective of things. And even if you're filtering content, to know that you're filtering content that is actually harmful and not just content because that is what the AI picked. And then I feel like the next recommendation is to states. I think our states, especially African states, do not call out big tech companies more, because if you demand accountability from the big tech, there is not going to be these issues of data protection and the issues of filtering certain content. Lastly, we need to do a lot of digital literacy, because there's no point of having the internet and all these access, and yet people do not know how to actually access it. Yeah, that's it, Ivy. Okay, thank you so much.
Thank you, Eddie. The research, the main points of the research have come out clearly. And as you spoke of the algorithmic biases, the question that we had you boldly asking was, is the information that we find online truly the information that we need? And what role do algorithms play in shaping access to information, especially in Africa's digital spaces? So thank you. We look forward to delving into the article itself and getting more answers. Thank you so much, Wendy. Moving on now to Nomiezo, who is a multidisciplinary human rights lawyer with a demonstrated interest in environmental law, climate justice, and digital rights. She advances and advocates for social justice through law, research, poetry, and policy recommendations. Her latest work includes making contributions towards a SLAP toolkit. So this SLAP is SLAPP, I believe standing for Strategic Lawsuit Against Public Participation, for African environmental lawyers and climate activists who find themselves facing legal reprisals from the state and other perpetrators of human rights violations. Nomiezo's presentation will be on misinformation and disinformation in the digital age and its impact on the information ecosystem. Nomiezo, please take the floor. I see.
Thank you so
Okay.
much. Do you see me now?
I see you, and I hear you.
Okay. Thank you so much, Ivy and colleagues. So I'd like to start off my presentation by saying that they are saying that bad things are happening in South Africa. And I'm not sure if everyone is aware, but about a week ago, the world witnessed a conversation between Pretoria and Washington, where President Trump and President Ramaphosa had a meeting to address the tensions between the two states. And one of the causes of that tension was being white genocide, apparently. So when I drafted my article on the information disorder and the impact it has on the information ecosystem, it was premised on a tweet or an ex post that blew up into a racially polarizing hysteria based on disinformation that was propagated mainly by two actors, and one of them being Elon Musk. Where he was accusing President Ramaphosa of allowing violence to take place against white farmers and the white people of South Africa. So this escalated to this video of Julius Malema singing a certain chant being used as a political agenda to further people's political agendas, was to win elections, which happened in 2024. So when I drafted this article, I could have never imagined that disinformation would escalate to levels where South Africa is sending off refugees of white genocide, a genocide that does not really exist, to the United States of America, nor could I have foreseen that this issue would wind up in the Oval Office. So we now find ourselves in a reality where the natural understanding of the world is being severely distorted before our very eyes and creating a space for the proliferation of gross human rights violations and the deepening of inequality. The promotion of access to information and the freedom of expression is meant to foster an environment of transparency and accountability, and subsequently the enjoyment of our democracies and the rights that come with it. But when President Ramaphosa had to account for this imagined issue, I would say, to assuage the world, and President Trump, I would argue that South Africa firmly upholds the tenets of a constitutional democracy, and all those who live within the country may enjoy the fruits thereof. We observed how the attempt to set the record straight was derailed by personal agendas and the doubling down of disinformation, even going far to use doctored, outdated, and edited footage and images. And this is the classic modus operandi of people who create and perpetuate information disorder that I discussed in the article. The same way that we saw the Julius Malema video of the chants being played during elections, we are seeing it now for geopolitical agendas. These inauthentic and coordinated behaviors are usually coupled with the blatant scientific and factual denialism, and they are usually employed to create an environment for the prioritization of transactional business practices, as we have seen. And I believe this is why it's important to be able to identify and understand the creators of information disorder so that we can see through their agendas and combat the ulterior motives that they may have. For lack of a better word, piercing the veil through their intentions. So in the same week, the Minister of Communications and Digital Technologies issued a policy directive to ICASA, which is the Independent Communications Authority of South Africa, to urgently issue regulations allowing equity equivalent measures to be considered for broadbands seeking regulatory approval. So the timing of this policy directive largely suggests that it was issued in response to the information disorder created by Elon Musk, complaining about being barred from operating his satellite internet service in South Africa due to race-based laws. Now, these race-based laws are basically the Triple BEE, which is a socio-economic policy in South Africa that is designed to promote economic transformation and enhance the participation of Black people in the economy. And it ultimately aims to create equal opportunity economy and address the legacy of historical discrimination. So it's obviously apparent that the easing of the Triple BEE would undo just years of transformational laws and further deepen the inequality that exists in South Africa. So I would also like to say, though, that I don't think it all is bleak. And as much as we saw this level of information disorder at such a public platform and in such an important space, I do believe that an unintended consequence of that event is that it has radicalized actors in the information ecosystem to act against disinformation and misinformation by actors, and it has inadvertently resulted in the improvement of digital literacy and the intentional debunking of information disorder. We really see this in the news reporting from the various channels that have been debunking the material that was shown in that conversation and that have been diligently fact-checking. We have seen this in the public figures that are making statements about the true state of things in South Africa. And we've also seen one of the doctored images that was used in that conversation. We've seen the son of the parents whose memorial was manipulated to depict this white genocide come out to the news to actively debunk this myth. And I'd also like to even go further to say that I would like to make the assumption that in light of this new policy directive, I believe that South Africans will be mobilized and compelled to comment and make inputs on this directive to prevent the triumph of information disorder, and which would lead to increased public participation within our democracy, which has been a problem in South Africa due to political apathy. And I see Ivy, I promise I'm going to wrap up. So I think to conclude, let me just quickly conclude. Bad things might be happening, but I also feel that there is significant potential in good things happening. I feel like if we keep fighting the good fights by making use of good media information literacy, digital literacy, practicing proper social correcting skills in line with international regional laws and regulations that really frame how disinformation amounts to human rights violations, I think we could successfully combat the information disorder that is just pervasive in Africa and all over the world, and boost the access to accurate access to information in Africa. And I think I'd like to end off by saying that one last recommendation that I would like to add is, I think Advocate Pansy Tlakula mentioned it, that we probably need to impose a higher duty of care on world leaders and people involved in international relations on just exercising, she called it information integrity. And I think that would be an important tool in boosting access to accurate information in Africa. So thank you. I know I might have gone a little bit on, but thank you for allowing me to finish. And I'm welcome to any comments or questions.
Thank you, Nomiezo. I think what we have had you say is that access to information, but access to information does not make sense if the information that we're accessing has been is false, if it's misleading, and if it has been weaponized, as the
Yes.
examples of such scenarios that you have given. Thank you so much. So now, and thank you to you and the other panelists as well. All presentations have been very, very insightful. And these contributions have been brilliant. So now it's your turn, dear participants. We are now opening the floor for questions and for comments. Feel free to raise your hands, to drop a question or a comment in the chat. And
Ivy,
yes, Lindiwe.
maybe let's move on to Isaac and then we can, yeah, thanks.
Okay, so the questions can be coming in the chat, even as we then have our final speaker, so that we consolidate everything together. We'll address everything. So Isaac is a consultant and a trainer on matters journalism, digital media, and elections. He is also a member of the the African Alliance for Access to Information, and he will be taking us through 3 recent Commission resolutions, which are on access to data and human rights, on assessment of public interest content, and monitoring tech companies in respect of their duty to maintain information integrity. So he will tell us a little bit about these resolutions, their key provisions, and the evolving approach of the Commission towards freedom of expression and access to information in the digital age. Isaac, I'll give you 5 minutes as well.
Thank you, appreciate. So I want to link this to what the Special Rapporteur said earlier about work that now needs to be done. And what I'm going to present to you is a process currently underway about a series of consultations to develop a set of new guidelines on behalf of the Special Rapporteur. So just to explain where this fits in, and I'm just trying to find the right buttons here, so just bear with me for one moment. Right, found the button. So we heard from the current and a previous Special Rapporteur earlier, and about the model law, and about the one set of guidelines that was issued on in terms of the model law, and then the Declaration of Principles on Freedom of Expression in 2019. Now, the problem here is that we have all those countries that adopted access to information laws since the publication in 2013 of the model law. But the model law is silent on digital rights or on anything regarding online. You won't find the word internet or digital or online in the model law. Meaning that the countries that used that and didn't go beyond what the model law prescribed have actually not adopted laws that's fit for purpose in the digital age. And in fact, what happened many times is they now have a whole range of laws dealing with digital issues, from surveillance to online crimes and a whole range of other laws. But the basic law about online rights as part of access to information is not in place. No wonder many African countries are struggling to get alignment between all these different sets of legislation. So in the same way that the guidelines on access to information in elections were developed and then issued, similar guidelines now need to be issued on on essentially making the model law or aspects of access to information legislation in countries compatible with the digital age. And for that, relying heavily on the fourth section of the Declaration of Principles. And I want to just show you quickly some of the issues that's mentioned in the 2019 Declaration of Principles on Freedom of Expression. In the preamble, for instance, it talks about open government data, which is obviously online access to open government data. It also affirms that the same rights that people have offline should be protected online, and makes a point that both of the special rapporteurs earlier made that access to the internet is central to the enjoyment of other rights. So in particular, part 4 of the declaration deals with access to information, as well as and then emphasizes universal, equitable, affordable, and meaningful access. Meaningful access usually have two meanings. One is about technical access, and the other one is to access quality content. In Principle 39 of the same declaration, it then deals with internet intermediaries and have terms like mitigation strategy, transparency, appeal mechanisms, remedies. Much of the stuff that you find, for instance, in community guidelines and in some of the recently developed instruments such as UNESCO's guidelines on the governance of digital platforms and so on. It also starts dealing with artificial intelligence, algorithms, other technologies used by internet intermediaries, which means digital platforms, that it should be compatible with human rights and law standards. So these are the type of issues that now need to go into guidelines that can assist states to apply or update their access to information related legislation. And this is essentially the 3 recent directives from the African Commission to the Special Rapporteur to develop instruments for freedom of expression, access to information, information integrity. And I'll just briefly give you an idea of what these 3 resolutions are about: on access to data, accountability and fact-checking, and public service content. And in the same way that the election guidelines should then be used by states, these guidelines to be developed should also be used. The first of the resolutions on 620 says promoting harnessing data access as a tool for advancing human rights. In particular, the Special Rapporteur needs to consult broadly, develop appropriate normative standards to guide data collection, deployment, access to issues, and in the process, support other efforts to promote and protect access to data in Africa. The second of the resolutions says in its heading, to monitor technology companies in respect of their duty to maintain information integrity through independent fact-checking. And then in the specific mandate, again, the Special Rapporteur must interact with different interested parties on monitoring the performance, information integrity, independent fact-checking. Those are the issues. The third resolution is slightly different in the heading and the mandate. The heading says, the assessment of public interest content in the digital era, guidelines to ensure public interest element. But when it then comes to the specific resolution and the mandate in the resolution, it talks about consultation of many role players to assess a concept of public service content in current times. And note that elsewhere in the same resolution, it makes a distinction between public service media, meaning public service broadcasters or state broadcasters, and then broadening the production of public service content to other role players. So this is not about public service media. It's about more role players producing public service content, bringing more diversity and plurality in the production of it, and utilizing many different ways to distribute it, including through public service media, but in many other ways to make it more accessible to more people in different countries. And this must be done within a future-focused policy framework for universal access to public service content in Africa. So those are the three resolutions. The Special Rapporteur is assisted by different organizations to do this. The African Alliance on Access to Data for 620, for 630 Media Monitoring Africa, and for 631, the Support Public Broadcasting Coalition. The plan with that is multi-stakeholder consultation session at conferences and webinars, which already started last month at DRIF, the Digital Rights and Inclusion Forum, which hosted sessions on this, and it's ongoing. Also looking at best practice research on these issues, want to get input from experts and organizations. Then the drafting of the guidelines will happen and hopefully adopted or considered by the African Commission end of this year and beginning of next year. And if all go well, hopefully to be launched before or at World Press Freedom Day next year. So I'm going to show 3 QR codes now where you can participate in the process. So I'm going to keep this on the screen for a few seconds. If you want to get out your phone cameras and get the link where you can give your input or register your interest to participate in any of these processes. So this is the first one, and I'm going to 5, 4, 3, 2, 1, go to the next one, which is a consultations on platform accountability and fact-checking. I'll scroll through these 3, and as we continue talking, I'll scroll through it again if you're not quick enough with your cameras. But 5, 3, 5, 4, 3, 2, 1. There's the last one. Give your input on resolution on public service content. And I'll get back to all of those. But my final message to you, 5, 4, 3, 2, 1, is please help shape our digital future. Participate in this. And let's see if we can come up with a good set of recommendations. I think I did it in 5 minutes, right?
Almost. Thank you, Isaac. You really tried. You condensed a lot of information and shared it in a very short period of time. Is there a way for people who are not fast enough to scan and do this? We can share the link afterwards for people to.
I'll just, as we go on, I'll just keep this on the screen and rotate.
Okay, thank you. So please get involved as has been requested. Isaac, thank you very much for that. And for now, I think we can now delve into the Q&A. Any questions, any comments, questions to Isaac, questions to Nomiezo, questions to Wendy, questions to Dunia, or any responses as well to any other presentations that have been made or interventions. The floor is open. I'm just going to check if there's anything in the chats. It's just thank you. No questions as yet. Don't know if we still have Nicholas with us. Nicholas, anything point you'd like to add that's a contribution to the discussion?
I wouldn't really want to add anything.
Hi, Nicholas. You're not very audible.
Okay. How is it now?
I can hear you, although the voice is, it sounds as if you're far from the microphone.
All right. I hope you
Yes.
can hear
Yes.
me.
That's better.
Okay. Yeah, so I was saying that I wouldn't want to add anything, save to say thank you for organizing this and for the launch and for all the speakers who have spoken on this important topic. Thank you.
Thank you, Nicholas. I think I'll pose a question to the others who made presentations today, asking about misinformation and we're working towards credible information. So how do we ensure that with greater access to information, the one that we are pushing for, that we can ensure that information is also credible, both online and offline? And the interventions can be, what legal interventions, policy information interventions, or they could also be institutional. What interventions do you propose to ensure the credibility of information, both online and offline? And any of you can take it.
I can start if you wish. There's a very interesting example happening at the moment in South Africa with the Competition Commission's Media and Digital Platform Market Inquiry, who published their provisional report in February. And their provisional recommendations include a couple of very important measures that can probably be copied in other countries. So while it is about the relationship between digital platforms and news media, that's essentially what it's dealing with. It also deals with, for instance, saying that platforms should change their algorithms to serve more credible news, credible information, so that they should down prioritize material that is not fact-checked, which is not verified, and they should prioritize material that's checked. And one very interesting and controversial recommendation that they make is that if platforms, well, firstly, they say that platforms must contribute to the media over a 3-year period, essentially share some of the profit to support struggling media because of, and I'm not going to go into all the details because why, but what I want to get to is they say that media producing credible content lifts the level of access to information that is that can be trusted across all platforms, and therefore such media should be supported. So one of the specific recommendations is that only media who subscribe to a industry-wide code of ethics, in South Africa's case, the press code or the BCCSA code, only those media should benefit from monies coming from the platforms. And they say to some of the platforms, they must also support independent media regulation. So that's a very positive way to deal with the whole ecosystem of information integrity.
Thank you. Thank you for that, Isaac. It was a comprehensive response, if I should say so. And even the lack of hands says so, is that you have answered it. So I think without further ado, we can now, because of time as well, wrap up our conversation. Managed to say thank you for being with us this far, for sticking it out with us. So I'll now invite Shengiwe to tell us goodbye.
Thank you so much, Ivy, for the excellent moderation and much appreciation really to everyone. I really want to extend our sincere thanks to each and every one of you for sticking around and listening to us And, we really don't take that for granted. Thank you so much for that commitment. So we began the conversation with Lloyd, who just gave us his remarks, grounding us in the significance of the discussions, and also Commissioner Topsy-Sonu reminding us that, through her keynote address of the ongoing challenges and emerging opportunities in the access to information space, and also urging us to remain very vigilant and innovative in promoting transparency and accountability. We then explored some of the, critical areas in the information landscape through Advocate Pansit Lakula from the perspective of oversight institutions. And really, let me also thank our thematic panelists, Prof. Tanya Zongwe, Wendy, and Nomiezo, for offering your deep insights. Really, that was really quite powerful, insightful, the issues that you shared with us, delving into the issues of the intersections of law, technology, and also bringing out issues of the information disorder that is currently being experienced, and some of the issues that have to do with the digital ecosystems. You had very good contributions demonstrating how multifaceted the right of access to information has become, particularly in the context of the digital era. And Isaac, thank you so much for bringing us full circle, highlighting the critical need for African-owned and, led digital rights instruments to safeguard access to information, freedom of expression, and also information integrity. And thank you so much to everyone who managed to speak. And, I think with this event, we have really reaffirmed that access to information is not just a legal or policy issue. It's a foundational element of democratic governance, human dignity, civic participation, and many other things as well. So on behalf of the Center for Human Rights, thank you so much to all our speakers, our partners, our participants, for making this day a success. I hope that you are going to read the newsletter. I hope you are going to reach out to us with any questions or you have any comments. So thank you so much. Have a lovely day.
Thank you.